Can we admit everyone now? Yes. Let's. Can you hear me? Can we run a test? Yes, it's working okay. We just did. Okay, we're ready.
I could not hear the Spanish translation. It was very soft.
We already have over 100 people connected to YouTube right now, and we are going to start transmitting the streaming. I'll tell you when it goes on live so that you know when to start. All right? Angela, we'll start once Diana confirms. Yes, please do show the slides. I'm going to hit it now. Please be silent, and I'll let you know when we are in the air. We're live on the air. Go ahead. Good morning, everyone. Actually, good afternoon. Some places. Welcome to the second session of our virtual training on environmental jurisdiction. With the help of ELI, CVGI, and the National Prosecutor's Office, and the Institute of Studies of the Public Ministry. We also begin the live transmissions through YouTube. We thank everyone for their interest in this tool and the inputs that we are learning during these 4 sessions. Before we get started, I'd like to remind ourselves some important ground rules to carry out the sessions. As you know, we will have simultaneous translation service. The Zoom screen, at the bottom of the Zoom screen, you'll find the interpretation icon. Please select the Spanish channel so you may listen to translation should you wish to do so, especially those who will speak English or Spanish. The sessions are being recorded and they'll be shared later. I'd also like to remind you to send your questions only through the Zoom chat. I'll be checking the questions and gather them to pass them on to the presenters later. As you may well know as well, with the support of the EM, will send a certificate to those who certificate their attendance and are present in the 4 sessions. Please watch for the forms that will be passed in the chat. We had some figure differences, so please, it's important that those of you who listen to this, please record your attendance or report your attendance. Before we start, I'd like to introduce today's agenda, today's session. We have a review from different examples of jurisdiction from other countries. In this case, we have 2 in the US. We begin with Jeffrey Patrick, who will be he'll be presenting the case of the environmental court in the state of Hawaii. We'll continue with former Judge Meredith Wright, who will be telling us about the situation environmental court in the state of Vermont. Then we'll listen to former Judge Anders Bengtsson, who will be joining us with the information about Sweden and other European countries and their experiences in this area. Then we'll finish with some references to other countries, the other countries that have done similar things by Meredith Wright. And then to finish, we'll have a QA session. Before we start, I'd like to introduce today's presenters. We have Jeffrey Ratley from Hawaii, the first tribune of the state of Hawaii. After 30 years in civil litigation, he was appointed as the first environmental court. He attended Williams College and San Francisco University. He received a PhD from Law Faculty of New York University. Former Judge Mary Flavory, you've seen her before. She works currently with ELI as an distinguished expert, judicial expert, and as a consultant in the role of environmental uh, courts, etc. She worked as a specialized judge in Vermont from 1990 till 2011. And then finally, we'll have former Judge Anders Bengtsson from Land and Environment Court of Bexhill. He has wide experience in the area of training regarding environmental authorities in the courts in Sweden. He worked as a judge of that tribunal from 2001 to 2019. He's participated with different organizations in trainings on that area. Thank you very much, everyone. And I leave you with the conference by Jeff Crabtree.
Good morning, everyone. I'm very pleased to be invited to do this. It's very early in the morning here, but still happy to be here. I always enjoy doing these. I enjoy meeting and speaking with people from other states or other countries and sharing our various experiences about environmental court. And, you know, in that spirit, our environmental court here in Hawaii has been going for 5 years now. We like the way it's working, but we certainly don't think it's the only way. And I'm just glad to offer, you know, my experience about our system for whatever value, you know, it may have for you. This first point might seem self-evident, but I make this point to every single group I speak to, that our environmental court is impartial. And the reason I do that is simply because many people in our community, at least, when they hear environmental court, they think it's it might be an advocacy type organization or agency, like say the Environmental Protection Agency. That is not our model. I am a judge, the same as all my brother and sister judges. I have a regular caseload with the environmental court cases on top of it. And we decide these cases based on the facts and the applicable law and our rules of procedure. And sometimes the environment wins and sometimes the environment loses, but we just feel that's the way it has to be in order to maintain credibility. You know, it may be different in other places, but that's how we approach it. The next slide, please. So here we have, you know, we have 4 main islands here that each have their own courthouses and each have 2 levels of trial court. There's our district court, which is sort of our junior court that handles smaller criminal and civil matters. And then there's circuit court, which handles the more sort of the senior trial court. It handles our more serious cases, you know, felonies for criminal court and the most complex cases for civil court. We have 2 levels of appeals court. First, our Intermediate Court of Appeals, and then our State Supreme Court, which can also basically take cases from the ICA if it wishes to. But usually cases all go to our Intermediate Court of Appeals first. Right, next slide, please. Thank you. So drilling down a little bit more on the types of cases that we have. In the district court, I mean, an example of that in the environmental context would be someone's caught by one of our conservation officers taking too many fish or using an illegal net. In circuit court, of course, much more serious. An example would be we have a colony of endangered birds, albatross, up on the north shore of this island. And a bunch of young people got in there and slaughtered a number of them, and they were prosecuted in criminal court, in circuit court, including jail time as a consequence. But circuit court also has, I do appeals from administrative agencies. So like if the Bureau of Land and Natural Resources makes a decision on an environmental issue, it comes to me for appeal. And I also get direct actions filed by private attorneys and private interests against each other and against government agencies. Next slide, please. So the environmental court judges, like I briefly said before, we have a regular case calendar. I am the only environmental court judge on the island of Oahu, which is the island Honolulu is on. The neighbor islands each have 2 environmental court judges for reasons probably not worth going into right now, but the environmental court judges are all designated by our Chief Justice Mark Rechtenwald. And we're required as part of the environmental court system that we have here to receive special training. We're required to have the training before we start hearing cases, and we're required to have the training at least every 2 years while we are presiding over environmental court cases. Next slide, please. All right, so a little more detail. The Oahu, where I am, has, by far the most residents in the state. Residents in Hawaii are about 1.4 million. And Oahu probably has at least 750,000, 800,000 of those. So we have a different system here than our neighboring islands, which is we have judges that do nothing but civil cases. I'm one of those. And then we have judges who do nothing but criminal cases. So in the environmental court context, if you allegedly commit an environmental court crime, you'll be heard by another judge beside me. Her name is Karen Nakasone. But if you are in the civil side of an environmental dispute, you would come to me. And interestingly, in terms of the Intermediate Court of Appeals and our Supreme Court, there is no environmental division within those courts. They hear all cases coming out of all environmental courts. So next slide, please. So just some brief examples of cases. In fact, the albatross case I mentioned, that's the picture on the left side of your screen. A number of them were slaughtered. And so those people were prosecuted in criminal court. The middle picture is just a picture of our coastline. Like many places, it's under duress for lots of reasons. And unfortunately, a number of homeowners here are tempted to engage in self-help, by throwing sandbags or into the ocean or onto the beach or building walls and so forth. That's all prohibited. You have to go through an environmental assessment process before you're allowed to do things like that. So we often have to deal with homeowners who are trying to do self-help. The little icon on the right-hand side of your screen is it's a poor example of a very serious problem we have. Like many islands, our water system comes from an aquifer that has developed over millions of years. And we have one here on Oahu that basically supplies, they estimate, at least 80% of our fresh water. And that's, again, for about 800,000 residents. So if that goes, we're in serious trouble. And unfortunately, there is a World War II era giant aviation fuel storage tank, 14 of them built directly above our aquifer. So that's an ongoing environmental problem that we've been dealing with for quite a long time. Another example is, just briefly, and then I'll move on. I don't want to get too bogged down in specific cases, but one of the aspects of our Constitution and our environmental system is our protection for Native Hawaiian rights. There's a whole section in our Constitution that protects ancient Hawaiian rights. And one example is what we call iwi, which is basically ancestral bones. If you're building a hotel or whatever, and during the excavation of the foundation, they find ancestral bones, buried hundreds or thousands of years ago, there's a whole environmental process that kicks in to protect Hawaiian rights. And Hawaiian rights are also blessed with very broad standing rules under our court. It's quite easy for a Hawaiian individual or organization to come in and raise issues in our courts. We do not make them jump through a bunch of procedural hurdles to exercise those rights because we want to protect those rights. Okay, next slide, please. So some statistics to give you some idea. Again, we're a relatively small state, 1.4 million. And these stats, the one on the left shows circuit court, the senior court. There have been 64 environmental court civil cases as of August of 2019. I tried to get updated stats, but with our COVID-19 process going on, it's quite difficult to get some things done these days, but it gives you some idea. And so that's only a 4-year period. We had 64 cases, 37 criminal cases. Interestingly, on our criminal cases, the vast majority of them are on the island of Maui. We've only had 1 or 2 on Oahu, which is a much bigger island. And there's a lot of reasons for that that are, anecdotal. My sense of it is that it probably has a lot to do with the prosecutor on each island and their prioritization of environmental cases. On the right-hand side of your screen, you see our district court filings, again, relatively small violations like taking too many fish or using illegal nets. And we've had over 5,000 of those cases during that same time period from the start of our environmental court in July of 2015 to June of 2019. Thank you. Next slide. So this is a little bit about our training. The whole purpose of our Environmental Court Act, and by the way, just as background, it came from our legislature. In some places, environmental courts are created administratively in the judiciary, but here it's an actual act from our legislature that was passed in 2014, effective 2015. And we think there's some value to that because, to get anything through our legislature, like most places, it takes some buy-in from all 3 branches of government. The legislature, of course, is involved, and the executive branch is involved, and the judiciary gave testimony on the issue. So there had to be an agreement reached about how this is going to work by all our different branches. And one of the things you see here, Act 218 on the screen, that one of the purposes was to promote our natural environment through consistent and uniform application of environmental laws. And that's why we have appointed environmental court judges so that they can get familiar with these cases, which are often very complex, and so they can get the special training that they need in order to do the job and do it in a way that's hopefully reasonably consistent. And just a moment on that, it's going to vary obviously from place to place, but here, our environmental court cases are some of the most complex ones we have. They often involve constitutional provisions, statutory provisions, local ordinances, administrative regulations. They often involve legacy type issues that have been going on for decades. They're often on the front page of the newspaper. And frankly, it's a lot to ask of a new judge who hasn't had any training. So that's one of the reasons we focus on the training and to help our judges decide those cases. Next slide, please. So some of the benefits that we see, at least from having designated environmental court judges, because again, just to step back for a minute, on the island of Oahu, where I am, it's circuit court, the senior court level. There's 8 of us, 8 different judges who could hear any particular civil case. And the way it usually works, you walk down to the courthouse and you file your lawsuit, and it's just sort of a wheel. Whatever judge is up next gets that case. So theoretically, any of 8 judges could get any environmental court case that gets filed. But again, with the way our system works, they all come to me now, as long as I'm designated by our CJ as the environmental court judge. And what we see is that we think it results in less forum shopping. If you've got 8 judges that you can get your case in front of, there's lots of games you can play about how to try to maximize your chances of getting it in front of one judge or another. You can even file on a different island because of the jurisdictional rules that we have. So a case that really belongs on Maui can get filed on Oahu. So we just think when you know who the judge is, there's a lot less energy placed on forum shopping. Again, specialized training and institutional knowledge is an obvious benefit. And as I mentioned before, more uniform and more predictable application of the law. All right, next slide, please. That might be it. I think it's the end of the show. Just briefly, couple things that I did not have a slide about is I have to tell you, just from my personal experience, I did not practice environmental law. I practiced law for 30 years. I did all civil litigation. I never had an environmental court case. So I become a judge in 2014, and 2 years later, here I am on the environmental court. It is really helpful to me to get one environmental court case after another, because that's how I really learn. I mean, the training is certainly helpful, but getting the cases and having to, you get these complicated motions that force you to dig deep and learn the law and read the case law and digest and internalize the principles involved and the constitutional doctrines and the protections that we're trying to enforce. And you build your knowledge from case to case to case to case. I mean, I've been doing this for about 3 years now, and I am so much farther ahead of where I was when I started. And that just wouldn't have been possible if I was one of 8 judges just getting the occasional random case. So I'm a big believer in designating judges as environmental court judges, because I mean, that's how you get the depth and the experience and the judgment to handle these cases. And that's the end of my prepared remarks. Thank you.
Thank you very much for the explanation and to see how it works in Hawaii. Now we continue with the presentation by Meredith Wright, the explanation of how the environmental court works in Vermont.
Hello, everyone. As soon as the slides start, I will start. Well, while we're getting started with the slides, here we go. Let me orient you to where the state of Vermont is in the scheme of things. It's about as far away from the state of Hawaii as is possible. Can you go to the next slide with the map, please? So Vermont is a very small state in the northeast part of the continental United States. It is, next slide, please. It is about the size of Belize, and tourism and agriculture are very important in the economy. So Vermont has had very strong environmental laws for a long time, since the 1960s at least. But the enforcement of those laws and the application of those laws was not as strong as the text of the laws themselves. So let me first describe the court system briefly, and then how the environmental court, which was created, again, as Judge Crabtree said, as a legislative act in 1989, with the court starting work in 1990. I'll go into how it gets started, what its jurisdiction is, and how it works. So because Vermont is so small, we have just a trial court level and our Supreme Court. There is no intermediate appellate court. The state has 14 counties, and within each county there is a courthouse. Divisions, the other divisions of the trial court, the Superior Court, handling criminal cases, civil cases, family cases. There is one of these per county. But the environmental court was not set up to be handled, distributed among the counties in the state the way the other courts are. In the least populous counties, sometimes a single judge will handle the criminal, civil, and family jurisdictions. So there's plenty of work to be done. Next slide, please. The situation in 1989, before the court was established, was that some of the environmental enforcement went to the regular civil courts, some of it went to the regular criminal courts, some of it was only handled administratively, and even inspections were done in a spotty manner. So starting in 1990, a single environmental court for the whole state was created. It was for some time called the Environmental Court of the State of Vermont, and its procedural rules, it has its own set of procedural rules, are still called the Rules of Procedure for Environmental Court. But when the court system of the state was coordinated about 10 years ago, it became the Environmental Division of the trial court, the Superior Court. But it is still a statewide court. It's separate from the other trial courts. It now has 2 judges. When it was started, it had only a single judge, myself. And the judges work out of an office or out of a courthouse near where they live, but they travel to hold hearings in a courthouse near the place where the case arises. So the participants in the case do not have to travel throughout the state to reach an environmental court. Next slide. So the first set of types of cases that came to the environmental court, its initial jurisdiction, dealt with a new kind of enforcement case that had not existed before. This is a type of enforcement system which starts with an administrative order issued by the environmental agency, which unusually can include money penalties. And in order to balance this new authority given to the administrative agency, the legislature created a court in which any of these cases could be transferred if the respondent or the person receiving the order wanted a hearing, a proper hearing on any aspect of the order, whether it was requiring something to be done or stopping some kind of work or the amount of the money penalty. These kinds of orders included enforcement of all of the state environmental laws and permits, including the state development permits, which cover large. We have a system where the small cases involving development are handled by municipal boards that issue the permits, but for very large projects, it is also required to get a state permit issued by state level regional boards. Next slide. The purpose of this law, and I'm going to go into these purposes because this seems to be the reason in most places for the initial creation of an environmental court. The purposes of this law were not only to enhance the protection of environmental and human health, but also, and this is very important when it comes to talking about the economic penalties that can be imposed, to prevent the unfair economic advantage obtained by people who operate in violation of the environmental laws. The situation before this type of enforcement was created was, and I'm sure this will sound familiar, is that the people who were law-abiding and who got the appropriate permits and complied with the terms of their permits For example, limiting the amount of a certain kind of tree that could be cut down, found themselves taken advantage of by people who operated without complying with the law and who obtained a much larger profit by violating the environmental laws. The other purposes of the law was to provide for more even-handed enforcement. As I said, both the inspections and the bringing of enforcement cases varied according to which law was being enforced, the number of inspectors under that program, and where in the state it was occurring. Also to foster greater compliance overall with environmental laws and to deter especially repeated violations of environmental laws. Next slide, please. The court worked for about 5 years under only this program, plus a couple of other temporary programs that were meant to close illegal landfills and a few other things. But in 1995, a large amount of jurisdiction was added to the court. This, unlike the original jurisdiction of the court, these were cases that were going to the general courts all over the state. These were all of the development permit appeals and plus enforcement of municipal development permits. These cases were tending to, we have a saying, be put on the back burner as if it was a cooking stove. These were cases where the judges who have to handle all the cases coming to a court found, as Judge Crabtree described, that these kinds of cases were more complicated and took more time during the, out of the limited time the courts had available to them. So they tended to be set aside while the courts were doing, while the judges were doing their other work. So putting all of these in the environmental court meant that they would get the attention of the environmental court. And then in 2005, a great deal more jurisdiction was added to the court. And since the work already was really too much for a single judge, they doubled the size of the court, which was to add a second judge. So in 2005, the added cases involved all of the state environmental permit programs, including the multiple kinds of permits that are required for starting a large project. Formerly, as I said, these went to either the general courts or to executive branch boards. They were not in any way coordinated. And one of the large advantages of the environmental court is that for any particular large project, all of the cases involved with that project can be coordinated, possibly heard together or sequenced in a way that makes sense for dealing with that project. Next slide. Because of a number of constitutional issues in the United States generally and in Vermont in particular, cases that have a right to a jury trial stayed in the general courts. The new environmental court with a single judge and no jury practice was not set up to handle these kinds of cases. But related cases, for example, where there is a development permit and a boundary dispute, and you have to determine where the boundary between two properties exists before you can determine whether the development requirements are met. The system is set up so that the environmental judge can be assigned to handle both of the cases, both the case in the regular civil court and the case in environmental court. So all cases involved with a particular problem or project can be considered together in their proper sequence. And if a hearing is needed, the different topics of the hearing that may require specialized evidence or technical evidence can be heard together so that all of the, it makes the whole hearing much more efficient. Next slide. So we have, because we have not so much time to go into the details of the court, I did want to spend a little time in talking about the factors involved in assessing a civil penalty, because this is one of the most powerful tools that the court was given in doing its work. And I think it addresses some of the problems that places that only have criminal fines find themselves somewhat limited in being able to impose a sanction that will make it more expensive to violate the law than to comply with it. So I will go into the other factors involved in assessing a penalty, but it's important to note that in addition to a penalty assessed for these other reasons, the court may recapture the economic benefit that resulted from a violation up to the maximum allowed in the statute. And that maximum has changed over time. I don't know quite what it is right now. So the way the court sanctioning process works is that when someone receives one of these administrative orders, if they want a hearing, the whole case is transferred into environmental court, and the administrative order is treated like the initiating document, which in our system we would call the complaint, for the court process. So it, even if the administrative agency has imposed a particular amount of sanction, the court holds a hearing de novo to determine what would be the appropriate, what was the economic benefit resulting from the violation and what might be the appropriate amount to recapture. Next slide. The other factors involved in setting and assessing a penalty are perhaps a bit more familiar to the people who deal with penalties in the criminal law system, but this is specifically a civil penalty and not a criminal sanction, so that a number of issues can be looked at outside of the, well, let me go through each of these factors and point out some of the important elements of them. The first and probably most important of the rest of these factors is how much actual or potential harm has there been to public health, safety, welfare, and the environment resulting from the violation. And I have underlined the word potential because many of the environmental violations that we deal with are at a point where harm may not have occurred yet, but it is very important to bring a case and to deal with the issue in advance of the harm if possible. So an example of this might be a drinking water system, which is required to test the quality of the water periodically to make sure that the water is safe for people to drink. There may not have been anybody getting sick yet, and it may be that the water is not actually contaminated. But if the water system operators fail to do the testing, there is the potential for harm to public health because you would not know if the water was contaminated. So this gives the system the opportunity to bring a case and to take an action if there is a risk to public health or the environment, not only whether harm has already occurred. Another element of the penalty system is whether the respondent, the person receiving this order, and you might say the defendant, I think, whether not only whether they knew that this violation existed, but whether they had reason to know the violation existed. And this is very important because you, if let's say a company president says, I had no idea that this violation was going on. You don't want to let the company off the hook just because the managers were closing their eyes to the existence of the problem. So you look at whether they had reason to know, not only whether they did know. The other elements look at the defendant's previous record of compliance, whether they have had cases before and whether those cases have resulted in a finding that there was a violation. Next slide. You look at the deterrent effect of the penalty. That is, the penalty amount might not have to be very large for one of the smaller players in a violation, but might have to be larger to have an effect on a large company. The length of time the violation has existed, which makes sense if a discharge of chemicals into the water or the groundwater has been happening for a long period, that's a much worse violation. But the factors also look at the presence of mitigating circumstances. And the legislature was so concerned that people would be, that the state would inspect and see a violation but not bring an enforcement action and allow the violation to continue, and then try to ask for higher penalties. So the legislature specified that one of these mitigating circumstances might be the unreasonable delay by the state in seeking enforcement of the situation. And then the statute requires looking at the state's actual costs of enforcement, of inspection and testing, and possibly also even bringing the case to court. Next slide. So that is an introduction to the Vermont Environmental Court. I talked more about the administrative enforcement piece of jurisdiction rather than the municipal cases and the state environmental permit cases. But I think it's important to lay all of that out because setting up an environmental court requires really looking into all of those issues. In the fourth session, the session that will take place on July 9th, we will go into many more of the factors that that people will want to consider in if they're considering setting up an environmental court. Thank you.
Well, good morning. And
Thank you very
Wednesday-
much. Before we start with the next intervention by Judge Andres Bengtson, I'd like to make a few comments. We have 280 people now. They're connected to the YouTube transmission. The attendance forms will be passed out after the first hour of transmission to make sure that we have everyone there participating. And I remind you that you can send your questions to the YouTube and Zoom chat windows to continue with the questions at the end of the session. Thank you.
Well, good morning again, even if it's 7:45 here in Sweden, so it's almost past bedtime. I will tell you a little about the Swedish system of land and environment courts, and also make some short references to other different approaches over Europe on how to deal with the environmental cases in court. On this picture, it's made by a local artist, Annika Nilsson Grünwald. She's made an illustration of the Land and Environment Court in action, and this could be almost any of our major types of cases at our court. It could be a civil case on compensation for damage. It could be an administrative case where the authority has ordered Mr. Beaver to destroy the dam. It could also be a permit case where Mr. Beaver applies for permit to keep the dam he already has built. But it could also be a criminal case, of course, but then not for a matter for the Land and Environment Court, which I will return to. Next slide, please. And you can continue putting on the, yes, thank you. I will give you a short overview of how the Swedish Land and Environment Court has evolved during time. The history can be said be started at 1919 when the water courts were established. At this time, Sweden was very poor, among the poorest countries in Europe. And but the urbanization and the industrialization had begun, and the water courts were created to be a one-stop shop for water operations and to facilitate industrialization and the development of Sweden. There were two major kind of cases: permits for hydropower stations and excavating of water to create land for housing and to create farmlands. In one decision, you can get permit to build, but also get a compulsory access to land and get a ruling on the economic compensation for intrusion and damage that you had to pay maybe to property owners up and downstreams. So from the beginning, the water courts were a totally independent system, but became part of the general court system later on. And so now they are special sections of 5 district courts. The appeals went to a special section of the appeals court in Stockholm, and then to the Supreme Court. And in major sense, this system is still running. In 1969, we got the legislation on the environmental or harmful operations, and then a national permits board or licensing board was introduced, and that was a kind of tribunal court-like institution that also handled appealed environmental matters from authorities. And also at this time, land courts were introduced that were handled land disputes. And the next involvement was when we entered EU, which introduced many new topics for the legislator. And in 1999, the Environmental Code was enacted, and then the environmental courts were introduced, and they actually were the former water courts that changed their name, but also got new cases to handle, and also got some, they were enlarging these this system very much, I can say. And some of the cases that formerly had gone to administrative courts were now allocated to these environmental courts. And then in 2011, the land courts were dismantled, and now we changed our name again to Land and Environment Courts. And we got planning and building cases as well as land disputes. And yes, next slide, please. Yeah, we can continue to next slide. This seems maybe a little messy, but you should have seen the picture before. So it has been streamlined in a way anyhow. So most of the environmental cases, they are going to the hierarchy of land and environment courts. So from the municipalities, there is administrative appeal to the county administrative board, and then to the Land and Environment Courts. And from us to the Land and Environment Court of Appeal, that's, as I said, is a section of the appeals court in Stockholm. Some cases can go to the Supreme Court, but most of the cases, they will stop at the Land and Environment Court of Appeal. Next slide, please. This is a picture of Sweden, and you see how here our 5 land and environment courts, and the one I represent is Växjö in the south. We have some 300 kilometers to the north and 250 kilometers to the south. So it's a rather big area to cover, and we are out a lot staying at hotels and have our hearings in schoolhouses and assembly halls, wherever we can find a place for us, because we go to the parties and try to facilitate for them instead of them going to Växjö for the hearings. And also we then often have inspection at the site, so it facilitates for everyone. Next slide. So we can say we are a mixed court, civil court, where we have disputes between neighbors and often regarding damage and so on. We are administrative courts. Most of our cases are administrative appealed cases. And we also are an authority because we have still this same function that the water courts had, and also the National Licensing Board had. So we can give permits for bigger water operations and also for larger industries, nuclear power plants or so on. So that's an object for us in the first instance. We can say we can take the next slide. Yeah, here we have the legislation that we handle. So depending on which kind of case we have, we apply different kind of procedural law, and also the substantive law is rather diverse with the environmental code. That is the big one. It was in a merger of 15 former environmental acts regarding waste management, chemical products, etc. And now we also have the EU law that is rather extensive, and it covers most of the areas of environmental law, and then we got the same minimum level in all the member states in Europe. So it's very important, and often in our cases we have to interpret our national law and put it in relation to the EU law, and then the EU law will prevail if there is a collision. Yeah, we can take next slide, please. Here you can see some examples on cases that we have. The figures are from 2019, so we see we don't have that many permit cases, especially not when it's for industries. Appeal cases, there is the heavy point, but seen individually, case by case, the permit cases are the heaviest. They can be, the surveys can be enormous, several meters of documentation they can cover on technical and scientific issues. And then we also have imposition of conditional fines. First, we can have an appeal case where an addressee challenges an order that is put with conditional fines. If you don't stop the operation or don't do that, you will have to pay a fine on certain amount of money. And if they don't obey this order, then we impose the conditional fines as the first instance. And then we have civil disputes, and you see the numbers are very few there. So if the person are not have any personal damage or economic loss, then they go to the authority instead and try to have them to pursue the case. And if they are not satisfied, then they can appeal. And this is without any cost for the complainant or any parties. Maybe if they have their own lawyer, it can cost, or they can have their own experts, but then they won't get paid for this in administrative cases. In civil cases, it's different. Then it's the loser pays principle that's applicable. Next, please. So here, the staff at the Land and Environment Court. We have 11 law-trained judges. This is the figures from my court. And we are judges. We have studied law as any judge in Sweden. And but to come to the Land and Environment Court, of course, it's would be regarded when you apply if you have worked in this area before, have the experience, or have knowledge in environmental law. But then what is special is that we have technical judges. They are engineers, chemists, experts in biology. We have architects. We have 3 land surveyors at our court for the moment. These technical judges, they are, when we decide a case, we will be a panel of a law-trained judge and a technical judge in most cases. If we disagree, then the chair will have a casting vote. But in major cases, we also have specially appointed members. They are appointed case by case, but the technical judges work permanently at the court. The specially appointed members, we have a list of them, and depending on what case, what the matter is, then we can pick experts from this list. They are often retired chief consultants, senior consultants, and so on. And so they are very, we think that it's very beneficial for our system in the more complicated cases to have more than one view on the issue. We can sometimes also shift one especially appointed member to another judge, for example, if there are many and difficult questions regarding law. And we also have a training for the judges, both a national program, but also a local at our court. And this program we have developed for all the categories of our personnel, so also for the drafting law clerks, they are younger lawyers, and also for the court secretaries, in order for everyone to be updated what is happening in the field of administrative law, but also in environmental law, of course. Next slide, please. Only some quick remarks regarding our administrative cases. They are rather heavy, but this is the tradition in our country for all administrative cases, that we have the ex officio principle, that the court will investigate the case on its own initiative. And we are not depending on the parties in that sense. We are, of course, bound by their claims, but which grounds they invoke, we are not bound by. If we find that the challenge decision is obviously violating some rule, but the applicant or claimant haven't invoked that error, we can still decide on it. We have a judicial and merits review. We have a reformatory procedure, meaning that in a way we are put in the same position as the first deciding authority, so we can alter the decision. We can put a whole new decision in its place. In many countries, they only have judicial review and a cassatory procedure. Either you say yes or you say no. We have no court fees, no litigation costs, and no requirement to be represented by a lawyer. And in most environmental cases, the burden of proof lies on the operator, irrespective if the operator is the claimant or the opponent. Next slide, please. So now I will give you a very short European view. And I will focus on administrative cases, as civil cases and the criminal cases are generally treated in the similar way in all the countries. And but when it comes to administrative cases, the Sweden, where we then have civil cases in the Land and Environment Court. And we are the only specialized environmental court in Europe. Finland and Sweden, we have a long mutual history, and that's why we in the administrative field have similar solutions. So they had the same system of water courts before, but now we have evolved in little different ways. But in Finland, in the appeals court of the administrative court in Vasa, they have technical judges. So when environmental cases are appealed from the administrative courts, and they are on environmental matters, they will go to this appeals court in Vasa, and then they can go to the Supreme Administrative Court. So this is a little different, especially then when you go to Denmark and Norway, that have neither of these countries had administrative courts. Denmark have a system of tribunals, administrative tribunals, but they are governed by law or judges that are chairmen, but they also have technical experts in them. And then if you challenge a decision from an administrative authority, it goes then to this tribunal. And then the decisions from that tribunal can be challenged by suing at the ordinary district court and will be treated as a civil case with the costs and so on. Also in Norway, you can challenge administrative decisions via the administration, but you can also go as pursue it as a civil case in a general court, but then of course you risk the costs. So neither of these countries have many environmental court cases in court a year. In UK, they have a little different system. UK, the mother of common law, you can say. There are no specialist environmental court, but some cases can be brought to the High Court and a special administrative division of the High Court. Then it's ruled by judges, but no specialist. There is a pending proposal at the Parliament that they should introduce. There is an institution called Upper Tribunal that is part of the administrative justice system. But it's regarded as a superior court of record and have the equivalent status of the High Court. And now the proposal is that some of the environmental cases should go to this tribunal, where they also have expert members. And the review is judicial as it is for now, but they will open up for what they call environmental review, but it's much more restricted than, for example, the review that we have in Sweden. The problem in UK states are the costs. They can be very high, but since there has been some judgment in the European Court of Justice regarding costs in court, when they look at the Aarhus Convention, that it says that it shall not be extensively costly for the parties to go to court. And then they found that UK and also Ireland has been violating this rule. So now they have introduced cost rules to lower the cost for the parties. Germany has got administrative courts, but no specialized environmental courts. But they often have, in almost every court, they have specialized. So the environmental court cases will be allocated to special judges. They have a cassatory principle at the court, so in principle it's yes or no, either they uphold the decision or not. And then they also have costs here, the loser pays principle, but they also have a rule that sets a cap on the winning party's amount for reimbursement if the lawyer's fees goes beyond the general rules. Netherlands, I will just say that they have a district court, and they are divided into 3 sections. One, the administrative law sector, and that sector will have the environmental cases. They have a rather interesting solution regarding knowledge in environmental matters, because there is a special authority that is funded by the government that can give expert opinions in environmental matters to cost-free to the administrative court, and that is rather successful. And in Netherlands, they don't either have the loser pays principle in administrative cases. I just want to finish with Spain, and next slide. I will only show you a tribunal that is protected by UNESCO as a World Heritage. It's a water court or a water tribunal. The procedure is purely oral and no writing, no records are kept. It consists of 8 members elected democratically by the farmers of, around Valencia, and its jurisdiction is the distribution of water between the various landowners and to resolve disputes between the farmers. It has existed already during the Islamic period, during the 10th century, so it's an extremely old institution, this. Next slide. So this is only to finish up and say gracias. Here you have a picture of our court, the workload for the technical judge that can be very high, and the law-trained judge, he has his or she their law book, and then you can take relax while the technical judge makes much of the works. But it's of course it's only a joke. In real life, we have to, of course, be well aware of what the case is about, also in technical matters. It comes with the experience when you have worked for many years. Thank you very much.
Thank you. Before we move on to the questions, we'll listen to Meredith Wright about some examples from other countries. Before we start, I'd like to tell you They're asking how to include jurisdictions from Latin American countries. In the next session, we will have Brazil, Chile, and Guatemala, who will be sharing their experiences from their countries in their environmental jurisdictions. And we'll be sharing later the slides of the presenters and other resources to read about these topics. Go ahead.
Thank you.
Bien,
There is
gracias.
only one slide
Es solo una diapositiva.
for this. If you will go on to the single slide for this session, the next screen. Thank you. So we definitely want to leave as much time as possible for questions. So I am only going to give you a very brief introduction to a number of different environmental jurisdictions that are organized differently. And bearing in mind that you are going to hear about Brazil and Chile and Guatemala next week, these are jurisdictions whose courts have developed different ways of handling, different ways of dividing the environmental jurisdiction between their courts and their administrative tribunals. First of all, I wanted to introduce you to the federal US, the national US system, which is actually an administrative appeals board or tribunal within the environmental agency. Otherwise, the environmental cases that arise under US federal law are handled in the general court system of the national court system. As you probably understand, because the US is a federal system, each state has its own court system and its own jurisdiction. And then the national court system is separate and independent of the state systems. And the different places may do things quite differently. Within its jurisdiction, the Environmental Appeals Board prides itself, or until it has prided itself on its independence, even though it is within the environmental agency. But this is a model that when the Vermont court was created, the Vermont legislature rejected this idea and required that the appeals process be housed within a judicial branch court rather than an administrative appeals board. In New South Wales, which is one of the states in Australia, also a federal country, the New South Wales Land and Environment Court is one of the models worldwide. It was the first specialist environmental court established in 1980. Vermont, I think, was the second, established in 1990. But it is a superior court of record that is completely independent of the other courts within the New South Wales judicial system. It has exclusive jurisdiction over both civil and criminal. That is, civil, which in the common law countries includes what you would call administrative. Civil and criminal, environmental, land planning, building, and mining matters. Its decisions go, although it is specialized and it has not only law-trained judges, but also science or technical commissioners, its decisions go to the general appeals courts, civil and criminal appeals courts, or the Australian High Court. It has an excellent website, including not only descriptions of the court and its operations, which are available for citizens of New South Wales, but its website also includes lectures and papers that have been written by its judges about the operation of the court. So it is an excellent resource for anyone looking at establishing a very well establishing an environmental court that operates in a comprehensive manner. Kenya has established both a specialized environmental and land court in its judicial system and a national environmental tribunal, which it's established to hear a lower level of issues dealing with the environmental impact assessments. And it was established to make it easier for ordinary citizens to have access to the courts for issues involving cases that affect them directly, with a more flexible dispute resolution mechanism and lower costs. So it is worth looking at the interrelationship of this environmental tribunal and the Environmental and Land Court, which is has the same status as the high courts of Kenya. Another court that uses a different model and is very much worth looking at as well is the High Court in Pakistan that covers the area that is located in Lahore. It has what you would call a green bench. I think they call it a green bench, and which has judges trained in environmental matters, but who also handle other areas of its jurisdiction. In one interesting case that is, I think, interesting, particularly in Colombia because of its work with watershed resolutions, the Lahore High Court ordered the establishment of a commission to come up with a resolution for a river system. And the court has held hearings to receive the reports of this independent commission, which was tasked with the requirement of determining a cleanup plan for this river system. Finally, China, which had no environmental courts up till 15 or so years ago, determined to run a pilot project initially in 5 of its regions and China has a very centralized court system with courts at the district level and then a regional level and a next level and then the Supreme Court. And it decided that the pilot projects had worked so well that they have established now environmental courts in most of their jurisdictions. So there are hundreds of environmental courts in China and established over a very recent period, and it's worth looking at their jurisdictions to see how the courts function in such a widely distributed way. So that is just a very short introduction to jurisdictions you might want to take a further look at. And I think we would like to open this up to questions and discussion as soon as possible. Thank you.
Thank you very much for the last intervention. I'm going to try to group some of the questions that we have received. Okay, here goes a question for the three judges. They ask about a case. Is a successful case, a case of high impact regarding the amount of the fine or the sanction or the impact on natural resources. Describe one case that has had a lot of resonance and has had a great impact. We can start with Judge Crabtree.
Was the question about fines?
No, a high impact case. I need a case that was relevant, big case, important case. It could be big in terms of the impact on the environment, or it could be a big case in terms of the sanction that was imposed.
Right, I'll be very brief on this one because the case is currently on appeal, but I just recently handled a case where the Army Corps of Engineers proposed to build a flood control zone to protect Waikiki against flooding in the case of a 100-year storm. And it involved building a series of dams across a number of our valleys, which the other side argued would displace Hawaiian heritage, environmental resources, and violate various environmental laws. No environmental assessment or environmental impact statement had yet been accepted for this multi-$100-million project. And the city was going ahead with funding for it. And under our system, you're basically not allowed to spend a whole lot of money taking steps to prepare for an environmental action until you actually have an approved environmental impact statement. Because the idea is we don't want to spend a whole lot of money and then the decision-making gets affected by the fact that you've spent all this money, and it can disturb the analysis by, oh, we've already spent, we've already spent $5 million planning these dams, so let's go ahead and build them instead of wasting all that money we already spent. It works, our system works the other way. You have to get an environmental review completed and accepted before you spend all that money. And so I basically granted an injunction stopping that project. So it had a major impact on this island, and it was $100 million in planning that, at least for now, is on hold. We'll see what happens on appeal. But I can't get into too many more details about it because it is on appeal.
Well, it's a little tricky to choose. Okay, so I can tell you just shortly about we have a region of farmlands where many farmers that would like to have their to excavate groundwater for farming purposes, and this was then colliding with the municipality that has the water resources were contaminated by salt water because there was they had excavated too much water from these reserves, and then the farmers applied for permit at our court, and then the municipality applied simultaneously for permit for their interest in order to give the public drinking water. So there was a big conflict, and we as this was a permit case where we decided in the first instance we could then resolve this conflict between the interests in a quite good way, I think. So everyone got what they wanted, more or less. And also we, this time, not as the previous water court made, we made estimations regarding the balance of water coming to by rain of flooding from the rivers to the area, and what was taken out by all the farmers in this region. So we could have every purpose at the table at the same time. It was very successful, I think. But we worked with that case for nearly 8 years. Thank you.
I just want to mention not so much a single case, but the cumulative effect of publicizing the results of issuing written decisions that are made public in a large number of cases, so that the populace sees, the people in general see that the laws being applied uniformly and fairly around the state, and that people are being not only caught and sanctioned when they violate the law, but that it becomes more expensive to violate the law than to comply with it, so that the publicizing these cases, even small cases, is a very important aspect of making the system not only be fair, but be apparent to everyone that it is fair. An important case, although not in the enforcement area, was a case where the legislature had passed a new law allowing or requiring that the groundwater resources of the state be treated as a public trust and be managed for the benefit of everyone in the state, so that the groundwater would no longer be treated as a private resource, which was the law 200 years ago, when much less was known about how groundwater actually works. And the state administration, the environmental agency, wanted to continue to impose the regulations about groundwater that had been in place before this new law was put into effect. And I ruled that because groundwater now had to be treated as a public trust resource, the administrative agency had to rework its rules to make sure that they all were meeting this new requirement. Even if the regulations turned out to be the same, they had to justify it on this new standard. So I think that was an important ruling, although not in the enforcement context.
Thank you. The next question is whether when a judge sees a risk of damage and takes a interim measure or a preventive measure, that same judge is in charge of following up on that preventive measure, or is it delegated to any other body of the administration of the executive branch?
Well, let me start. Generally, a request for a preventative measure from the court is filed at the very outset of a case brought in front of that court, in front of the judge who's handling that case. And it would be any enforcement of or review of that preventative measure and how it was working and whether it was being obeyed would continue to be looked at by the court. We have certainly have had cases where we have set up a schedule for the parties in a case to report to the court periodically to make sure that the preventative measures were being obeyed, and that rather than waiting for someone to come and complain that, you know, all the trees have been cut down or some other action.
Yes, and when we have such request, mainly the same judge that takes the decision on interim measures will take the final decision as well. But sometimes depending on if it's because you can be seen as biased by the first decision, but it has been also, I think, by the Supreme Court accepted that you do it in, you take the same, or the same judge will take the final decision as the interim, and that has been accepted. There is a difference, of course, if my decision will be challenged and then changed in the appeals court and sent back for any reason, then I can't take it. But otherwise, in the interim measures, I would take also the final.
Very similar here. I definitely receive motions for preliminary injunctions. Our standard is whether there's a likelihood of success on the merits, whether there's irreparable harm, which needs to be dealt with right away, and whether there's a public interest component of it. You know, depending, and sometimes my ruling on that preliminary injunction, which is by definition not final, actually resolves the case because the parties see the handwriting on the wall and decide to do whatever they're going to do with it. Other times I have a case now where we're cleaning up an old toxic waste site, basically, and we've been meeting almost every 2 weeks for over 2 years to go step by step by step. How are we going to manage this problem? So it really depends on the particular facts of the case. Thank you.
Another question has to do with the internal composition of the benches of the chambers. What is distribution? I mean, attorney that are not attorneys, engineers, biologists, what kind of profiles are chosen or are appointed to support the judges?
I had a little difficulties hearing the question. What is the...
I'll say it to you again. What kind of profiles are chosen to support judges? Like, are they biologists, engineers, architects? I mean, they're not always attorneys.
Yes, as I described before, in my country, we have inside the court internal experts, these technical judges. Of course, they are not experts in the real sense because they are more of generalists, but they have an academic degree and they have been working with environmental matters for a long time in order to become a technical judge. So they are very experienced and they have a different profession than, as I mentioned, architects, land surveyors, specialists in water operations, chemistry, biology, etc. And then we also have, in the Netherlands case, these experts, quite similar to our internal experts, they have an external authority that the court can give the case to and put its question, and then they get a report in return where the authority then give an opinion on the technical matters. In most other countries, they don't have such a system. You have it, will have it in the UK system, in that tribunal that they are building now for inter alia for environmental matters. But otherwise, it's quite uncommon that the court have internal or that close relation to the experts. Otherwise, the court itself, and we can appoint an expert if it's a very specialized area, for example, and the parties can they can have their own experts and they present their materials or documents in the court. So there are many solutions. And in most European countries anyhow, they have this cassatory principle that the court either say yes or no. Then they don't have to dig that deep into the technical issues that we have to, as we have this reformatory principle and ex officio obligation to investigate the case. So we really have this need for these experts, and the same goes for Netherlands. They also have a reformatory principle, for example. So I think that is the major division between the need of the internal or close relation to the experts.
And in the US in general, and certainly in Vermont, we don't have technical experts or scientific experts on the staff of the court. We are obligated to take all of the evidence that we're going to use in any case on the record of the proceeding. We're not allowed to hear about any of the technical, even not controversial technical issues. We're not allowed to hear them outside of the presence of the people in the case. So we have evolved methods of listening to and comparing the scientific and technical experts who are presented as witnesses by the different sides in the case. The procedural rules allow for judges to call their own witnesses, and that is not so often done, but more as a budgetary issue. And it's avoided in cases involving juries because the jury will give too much weight to the expert appointed by the judge compared to the other people in the case. We don't have time to go into it here, but the website of the New South Wales court, if you look at it, will list all of the expertise of their technical judges. And there is a procedure that has been developed in that court using experts from the parties who meet together and form an agreed upon report to the court. That is a very useful procedure. We can provide more information about that, but not right now.
And for us in Hawaii, we have very few judges who have any technical expertise on these issues. We do have the ability to appoint specialists to help inform our decision-making, but if and when we do that, all that information and discussions would be on record. There would be no private conversation between the court and the court-appointed expert. They'd write a report, it would be shared with all the parties, and everybody would get a chance to agree or disagree or what have you. But thank you.
Next question has to do with time. Is there a time limit for these decisions to be made? Is there a deadline for the sentence to be passed? Does the judge have a time limit, or can they prolong for years? I mean, to reach a judicial decision.
I'll take that one first because I'm I'm laughing because it's constant issue for me personally. Just like I say, I share a regular calendar. I have probably about 600 cases on my calendar. And at any one time, I might have 15 to 20 environmental cases, which take a disproportionate amount of my time. I'm not complaining, it's just a fact. They're more complicated. They take more time. And I am constantly in a fight with myself on how fast to get these decisions out because I'm juggling all these other matters, which are very important to the other parties in front of me. So it's just sort of a personal choice. We have an informal rule that I need to decide within 90 days of the hearing. Even that relatively short amount of time drives the parties and the attorneys a little nuts. So I try to get my decisions out faster. But it's just a constant struggle. The short answer is it depends. Sometimes I can rule from the bench. Other times it can take 3 to 6 months for me to pull everything together and write a cogent analysis. Thank you.
I don't really have anything to add to that. That was my experience as well. But there is no statutory requirement, but there are definitely standards that the managing judge, the chief judge, tries to keep everyone to, not just in environmental court, in order to get the decisions out in a timely way after the case is completely submitted to the court.
Yes, in my country, we have a mix. For example, in civil cases, we have a standard that 2 weeks after the main hearing, we should give the judgment. And in permit cases, where the judgment can be several hundred pages thick, we have 2 months after the main hearing. But otherwise, in administrative cases and also our dispute, we also have some guidelines that we have agreed upon all the land and environment courts. They are not binding, but we use them when we look at the statistics. And that is, for example, in appealed cases on environmental from the environmental code, 6 months from that they are submitted to the court, and some land disputes are longer, I think 9 months or something like that, but they are only guiding.
Just to tell you, we have received over 45 questions. Of course, we cannot answer all of them in today's session, but I'm trying to group them. I have 6 questions related to the same topic. How do you assess the environmental costs? How do you value environmental costs to make a decision? I know this only question would give another webinar, but in general terms, what is the criteria? What are the criteria? How do you assess environmental costs of natural resources in order to determine a sanction and to make a ruling, a decision?
That really does have to be the subject of a whole other webinar with economists speaking, but we are in the cases that we have where environmental damages must be assessed in monetary amounts. There has to be economic evidence from expert economists, natural resources economists, who will present ways of valuing the damaged resource. I think that there have been some very good articles written about how this was done in the very large US case involving the the Gulf of Mexico damages, both the damages to the ocean resources and the damages to the shoreline resources and the damages to people's livelihoods. So it might be worth taking a look at that, but I can't answer more specifically than that.
Just, it's very case dependent. I mean, water rights, marine life rights, cultural rights. I mean, how do you assess those? Those are tough questions to juggle. So I agree, it'd take a lot more time to get into some real detail. But one general observation I have is, you know, in Hawaii, like I said, we have about 1.4 million residents, but our economy is largely based on tourism. And before the virus hit, we were getting about 10 million tourists a year. So about 9 times our regular population was coming through every year. And there was often in prior years, there was often this feeling that it was sort of us or them. You know, are we going to protect the environment, or are we going to, max out tourism? And I'd say just in the last couple of years, I think there's been a growing realization that those things are not disconnected. That if we trash our environment, we're ultimately going to trash our tourism industry, because people are not going to want to come here. So it's been an interesting process to watch people rethink how the economy can relate to a healthy and clean environment. So I'm happy to see that analysis, because before it was more black and white, one or the other.
Yeah, I agree with you both, and it can be, sometimes it's rather not simple, but you get the investigations from experts, but often the problem is bigger than that, and how to weigh the interest of the nature against a development project, for example, that can be rather tricky. But there are evolving models for this, and it has been discussed much in the last years, and there are also a discussion related to directive, environmental liability directive from the EU, and so that has also started a discussion and put pressure on the member states in order to make models how to evaluate this damage and to restore. And we had, but this case was some years ago, protected species in the mountains in the north of Sweden called wolverine. It was shot by poachers, and then it went up to the Supreme Court regarding damage to the state, because the state had invested much money in order to protect this species, and then you destroyed some of these investments, so they could make some economic models, and the poachers were obliged to pay damage to the state.
Thank you. And to finish the last question, just 1 minute to answer per person, please. And it's about comparison, about the previous state where there was no specialized court, there was no environmental court, and now when we do have that specialty, do you think it's been more efficient? I mean, especially to sanction damages to the environment, to compare before and after the environmental court, what has been the impact? How has this impacted your jurisdictions?
If I start very quickly, yes, I think that this has improved much, because you, with experience and also the expertise of technical judges, we can solve the case much more efficient than if it was brought to a general court. By having a rather big workload, we get this experience, and also we get an ability to handle them efficiently as well. So I think it's, and it has been, in our country, we have been supported both by the NGOs and by the industries and the public. So I think that as we are regarded as objective and have the knowledge of environmental law, they have respect for us, and they rely on us.
I think Judge Bankston said exactly what I would have said. I'm all for it. I think it's improved. I think the community is reasonably pleased with it, and it's definitely led to more predictability, more uniform approach, just because you have fewer people making the decisions, if for no other reason. But the training in Hawaii has been key, and I think it's definitely elevated my ability to make good decisions. Thank you.
And I would just add that as the public, as well as the people who work in environmental fields or in the industry, as people become more aware of the outcomes of these cases, I think you actually have a reduction in the kinds of challenges when the law becomes settled and well known to people, and that certain types of violations will not be accepted by the state. I think the overall, it improves the overall approach of the populace, of people to the environmental field. And so we would have waves of cases, and this is not a question of the common law and precedent, because we are just one court at the trial level. We're not precedent for anybody else, but for the population to see that these issues are taken seriously, that they are handled efficiently, and that everyone comes before the law. I think it has improved overall compliance with the law and the attitude of people towards this field.
Well, thank you so much to all the experts who joined us from their jurisdictions. We conclude today's session. I'd like to make some brief comments before we finish. I want to thank those of you who have joined us. We have over 250 in YouTube, and there's been interesting discussion, which pleases us. We are convinced that one of the objectives of this is to contribute from the academia and from the compared cases, contribute to the discussion that is taking place in Colombia. I also want to invite you to our next two sessions. The next one will be with the people from judges from Brazil, Chile, and Guatemala. The last session will be addressing the recommendations, what experiences we can extract for our own territories. There are no questions about the certificate of attendance. It's only those of you who have attended the full sessions during the whole session. The attendance forms are available for about 10-15 minutes more, but only will we certify those who have joined the 4 sessions and recorded their attendance during the transmission. Thank you again very much, and hope to see you next Thursday. We'll be sending you the link with the time of our session. Thank you to the judges, and thank you everyone for your attendance.